This is my individual social problem statement video regarding the end-of-life care, specifically the importance of advanced care planning and promotion of self-determination, by Courtney Robison for Social Work 502 in the spring 2020 semester.
Remember, I will always be with you.
Imagine that your mother, father, grandmother, grandfather, or any other person who is near and dear to you is in the hospital due to a serious accident or illness. They are in critical condition and they need life-sustaining measures to remain alive. These could include procedures such as CPR, intubation, artificially supplied nutrition and hydration through means such as IV fluids and a feeding tube placed through their abdomen, or they won't survive. Due to circumstances related to their accident or illness, they are incapacitated and therefore unable to communicate their wishes regarding what they would want. Do you know what they would want? Has anyone had these conversations with them before this happened? And answers to these questions are needed. Do you know what they do not want or what they would not want? Have they participated in advanced care planning and completed advanced directives to direct their treatment decisions? The answers to these questions are needed now, and the time is of the essence. What are you going to do? The doctors are asking, and they need an answer. Who do they ask? Has your loved one appointed a healthcare representative to speak on their behalf if they are unable to speak for themselves? If not, Indiana law determines who can do this for them, typically a member of their immediate family, a spouse, parent, adult child, brother, or sister. What is their relationship with those individuals? Do they know what your loved one would have wanted? If they do, will they respect those wishes or do the opposite? Is that person you? And if you are not one of those specified individuals listed by Indiana law and you haven't been legally appointed as a healthcare representative, you may not be able to express the wishes for your loved one that they may have told you that they wanted, and they may receive the opposite course of treatment because those who are qualified by the law as the next of kin maybe are not as close to your loved one as you are and may not have their best interests in mind. However, they will be the ones who make those decisions over you because the healthcare representative wasn't appointed. Imagine your loved one's life hangs in the balance. No one knows what course of treatment they would have wanted in this situation because an advance directive was never discussed or completed. And you are the person who is emotionally closest to the loved one, but are not the one who is able to make the decisions because someone else is above you in the hierarchy of ranking decision makers specified in law, in the absence of a healthcare representative. And they may not have this loved one's best interest in mind. And they are the ones making this exponentially important literal life or death decision blindly. So I ask, does this make you feel uneasy? It should, and that is why you should care about end-of-life planning, the underutilization of advanced directives, the lack of education and outreach about advanced directives, and the promotion of self-determination.
You intubated her?
Yeah,
You intubated her.
I had to. She was struggling to breathe. Her sats were in the 80s. She was in her room all alone. What?
One of the temp nurses found the paperwork from her chart on the second floor.
You put a tube in Grace.
She put a tube in Grace?
She put a tube in Grace.
Mrs. Bickham was diagnosed with end-stage COPD. She's on hospice.
End-of-life care?
DNR, do not resuscitate.
You little schnook. You were supposed to let her die.
Advanced directive documents are legal documents which serve as an individual's written instructions regarding their wishes for their medical care and treatment. This is the amount and type of care they would want or not want under various medical circumstances. They may also name a person of the individual's choosing who would serve as the individual's voice to make healthcare-related decisions for the individual when that person is unable to make or communicate those decisions for themselves. Advanced directives do not take away the individual's abilities to make decisions about their healthcare treatment. Advanced directives will only be used when the individual is unable to communicate their decisions, or when determined by the physician to no longer have the mental capacity to make those decisions. Advanced directives are imperative in determining when, where, how, and how much care an individual wants at the end of life. This care needs to be determined by the patient via advanced directives and not by hospitals, insurance companies, or the government. Despite being free, readily available, uncomplicated, and straightforward forms, which should take only a few minutes to complete, too few Americans have completed them. This leaves their wishes and decisions about the scope of medical treatment unknown to their loved ones and to healthcare providers, potentially leading them to receiving or not receiving treatment they would want or not want, and leaving healthcare decisions to individuals specified by law, typically ranked by closeness of relation of kin. However, those with whom the individual are closest to emotionally may not be the ones appointed by law to make decisions on their behalf without being appointed as a healthcare representative. The population of individuals 65 years and older in the US is increasing. In 2009, there were 39.6 million people 65 and older, and it's estimated in 2030 that there will be 72.1 million people 65 and older. As the baby boom generation continues to age and be impacted by chronic disease and comorbidities and the advance in medical technology, making things like mechanical extension of life possible, it's inevitable that healthcare costs will rise. Completion of advanced directives will likely reduce healthcare costs. It is estimated that 25% or more of all healthcare dollars spent in the entire lives of individuals are spent on the last few months of life. This is very disproportionate across the lifespan. Large amounts of money are spent on keeping people alive far beyond any hope of reasonable recovery, which would be more appropriately spent earlier on when the impact would be much greater and more beneficial in terms of quality and length of life. Approximately 58% of those dying do so in hospitals and 20% in nursing homes, compared to 22% who die in the comfort of their own homes. Healthcare costs are greater for individuals in institutional settings, which would be more appropriately spent managing death at home when possible. Research has shown that the loved ones of individuals who have died in their homes with hospice services in place have reported a more favorable dying experience. More than 70% of patients receiving hospice die in their homes. Costs for end-of-life care are paid by private insurance, Medicaid, Medicare, and self-pay. 30% of Medicare spending is spent during the last year of life, and 50% of that is in an acute care hospital. Taxpayers, employers, and individuals are all paying for these costs. Studies have shown significant differences among racial and ethnic groups in the rate of completion of advanced directives. Twice as many whites as African Americans have completed the forms. A study in Maryland in 2013 showed that more than 60% of people 18 and older wanted their end-of-life wishes to be respected, but only 1/3 of them had completed the advanced directive forms to make that possible. Initiating conversations about death can certainly be challenging and awkward, but they are important conversations to have. Progress in medical technology has led to increasingly complex medical care choices. The history of public opinion and personal values regarding the artificial extension of life versus allowing natural death with comfort measures in place, along with the advancement of medical technology making things possible that were never possible before, all play a pivotal role in the end-of-life planning and whether or not advanced directives are completed. Sophisticated medical developments were introduced in the 1950s and 60s, which made possible the reality of prolonging life and extending the dying process by administering life-saving medical treatment. These advances in medical technology complemented the idealism of the promotion of saving lives at all costs in the 70s. Concerns related to whether or not to administer life-saving measures, how long to do so, medical and economic ramifications of administering or withholding life-saving treatments are all concerns with the emergence of medical technological ability to sustain life. The conversation of advanced directives has not yet become a standard routine part of most medical exams, and until these discussions become more routine, the completion of the appropriate forms won't be where it needs to be, and the conversation will still be scary. Once it becomes more normalized, completion should increase and the topic will gradually become less challenging to discuss. There has been a scarcity of information and data regarding the prevalence of advanced directives across the general population, which creates challenges to the development of evidence-based policies. 25% of those in the 2013 Maryland study who had not completed advanced directives reported not doing so due to not knowing about the forms. Others felt they were too young or too healthy to complete them. Others yet were concerned about the cost of completing the forms, the complication of the forms, or the time that may be required to do so, not knowing that they are free, relatively straightforward, and only take a few minutes to complete. Others felt more comfortable receiving this information from their healthcare providers as opposed to attorneys, clergy, or online resources. This means that healthcare providers have an important role to play with relation to advanced directives, educating patients about these forms, and providing guidance on how to complete them. The differences among racial and ethnic groups in the rate of completion of advanced directives is likely to be attributed to several factors such as cultural differences in family-centered decision-making, distrust of the healthcare system, or poor communication between healthcare professionals and patients. It is possible that new systems, such as accountable care organizations, electronic medical records, and aligning incentives will help reduce expenses without costing undue harms to patients and providers. To the extent that expensive, futile, and often painful care is foregone, money will be saved in the system, but not in a manner of disregarding human life to save money, rather to respect the wishes of individual patients. Many healthcare systems are even updating terminology, such as utilizing allow natural death instead of do not resuscitate. Healthcare professionals should be involved in discussing these issues with their patients and honoring advanced directives. In looking at policies that address the problem, there are 3 policies that I would like to mention. The 2010 Patient Protection and Affordable Care Act, Indiana Code 16-36, and primarily the Patient Self-Determination Act of 1990. The 2010 Patient Protection and Affordable Care Act applies to patient autonomy and self-determination as it expanded the use of electronic health records that have facilitated and assisting healthcare clinicians to get appropriate access to advanced directives information in an accurate and timely manner through advanced directive registries. This is important to ensure that if an individual has completed advanced directives, that they are easily accessible and able to be carried out when necessary. Indiana Code 16-36 applies in that it allows any member of your immediate family, including a spouse, parent, adult child, brother, or sister, or a person appointed by a court to make healthcare decisions for you in the absence of an appointed healthcare representative through an advanced directive. The primary policy that I feel applies most to patient autonomy and self-determination is the Patient Self-Determination Act of 1990, or PSDA. Prior to the implementation of this act, there was much political controversy over the concept of patient autonomy, self-determination, and the humane right of human beings to choose to die with dignity if they so choose. Several well-organized, sophisticated, and politically respected groups, including the American Hospital Association, the American Bar Association, and the Healthcare Financing Administration were initially reluctant to support the passage of PSDA. Some groups and various right-to-life organizations were also initially not in agreement with PSDA and lobbied passage of legislation promoting patient autonomy, including the American Medical Association and the Catholic Church. Doctors also varied in opinions about patient autonomy. Doctors operate under a do no harm ideology. Some doctors felt that do not harm meant to prolong life at all cost, while others felt that this was not a promotion of do no harm and did the opposite, as artificially prolonging life was actually doing harm. Several interest groups, such as the Society for the Right to Die, lobbied for patient rights and wanted to increase patient autonomy. They felt as though although it was possible to prolong life itself, that didn't mean that health would be restored or quality of life could be provided to patients who were permanently incapacitated. There were cases where the use of life-saving measures were used against the wishes of family members on terminally ill patients who had no hope of recovery. The implementation of this act made it a reality for the legal rights of competent adults to exercise self-determination regarding their health care and end-of-life treatment choices. There were years of legal battles, ethical debates, and bitter controversy surrounding the issues of patient autonomy. Landmark legal battles, such as the case of 21-year-old Karen Quinlan in 1975 and 25-year-old Nancy Curzan in 1983, both patients who were in permanently incapacitated states following accidents and were kept alive for years against the wishes of their families, until years of litigation ruled in favor of the families to withdraw life support, demonstrated why the issue of patient autonomy is so important. Following these and other court cases surrounding this issue, it's probable that policymakers made the logical assumption that most individuals would choose to forego life-saving measures in the face of certain impending death if given the opportunity to complete advance directives. The Patient Self-Determination Act was implemented in December 1991 as a part of the Omnibus Budget Reconciliation Act of 1990. PSDA was introduced and sponsored by former Republican Senator John Danforth from Missouri, Democratic Senator Daniel Moynihan from New York, and the Democratic State Rep Sander Levin from Michigan. Signed into law by U.S. Congress. Supported by legislators and policymakers of both Democratic and Republican parties, and endorsed by the American Medical Association, American Bar Association, and various advocacy organizations, including the National Association of Social Workers and the American Hospital Association Society of Hospital Social Work Directors. This act promotes the legal authorization for competent adults to document their end-of-life wishes about the use or non-use of life-sustaining medical treatment in advance of incapacity. This act requires patients 18 years and older being admitted to Medicare and Medicaid-funded healthcare facilities to be informed of their right to accept or refuse life-sustaining medical treatment in the event they were to become terminally ill or permanently incapacitated, as well as providing them with the written information about their options and given the opportunity to complete advance directives. PSDA requires advance directives documents to be available in all Medicaid and Medicare-funded health facilities. PSDA also requires the healthcare provider to be responsible to document the existence of advance directives in the patient's medical record, ensure compliance with state laws, maintain organizational policies and procedures, and provide education regarding advance directives. Healthcare providers provided to a patient cannot be conditional on the existence of advance directives. PSDA applies to a variety of healthcare systems, such as hospitals, skilled nursing facilities, hospice, home health care agencies, among others. The underlying assumption of PSDA is that increased awareness and information on advanced directives will generate discussion between people and their healthcare providers and result in an increase in completed advanced care directives. Thank you.